Remember that Judge Masipa handed down correctional supervision as the appropriate sentence sometime last year. So what we have here is not that strange, considering that direct imprisonment was not imposed from the outset. So unlike the thoughts out there saying that he received a lenient sentence to be out on 10 months' time, in terms of our Criminal Procedure Act, that is exactly what correctional supervision entails in terms of Section 2761I, which is the applicable sentencing option Masipa imposed in this instance.
And what will be the conditions of his bail once he gets out?
Yeah, what happens now is the remainder of the 5-year term that she imposed will now be served under ordinary correctional supervision. That means that he will be under house arrest, he will have to undergo certain programs. Obviously, victim compensation might also be on the table, things like that. It's a kind of an umbrella sentence. So a lot of strict rules will be imposed by the Department of Correctional Services, but for the remainder period of the 5 years, in other words, the 4 years and 2 months, that still needs to be done. That will be served outside of jail under house arrest, unless, obviously, the state is successful in the appeal that should be heard during more or less November this year in Bloemfontein at our Supreme Court of Appeal.
But house arrest means he can't leave it or go about town or have access to a car. He literally has to stay in his home.
That is correct. What usually happens is they can attend your house at any time of the day or night to come and check up on you. Usually it entails that you must be at home at a specific time in the afternoon, usually around about 5 o'clock, and then obviously you're not entitled to leave home unless that is for work purposes, which means that you must go to work, back home, work and home, and that's it. You're not allowed to go outside the jurisdictional area of the magisterial area, in other words, in this instance, Pretoria, unless obviously you have the consent of the department and your correctional supervision probation officer.
What about visitors? Can you have as many visitors as you like in these circumstances?
Yes, obviously, there's no prohibition on that. As a general rule, the issue comes in that you're not entitled to live as a free person because you're still under a sanction. Remember, there's still the remainder period of the 5 years that must be served. However, obviously, there will be scrutinization of those members of the public and family members that want to come and visit. It won't be a carte blanche for everybody to come and go as they pleases. There will be strict rules in this instance as well.
And how about access to firearms?
No. Obviously, that will be a big no-no. You remember he was also convicted on a second charge for the discharging of a firearm. And one of the conditions that is automatically implied in our Firearms and Ammunition Act is that you're not eligible to possess a firearm unless the court directs otherwise, which in this instance did not happen. Therefore, for the rest of his life, he will not be eligible as a general rule to have a firearm or even to possess a firearm, never mind to discharge firearms in the public and so on.